we proceed with the issues for discussion today. Barrister Dejolalaye, can we have your thoughts on the alarming figure of awaiting trial inmates at the correctional centers in Nigeria?
Thank you very much. I think the clip that we just watched actually tries to give us some statistics as a background to the unquestionable number of people that are still in correctional centers, formerly known as prisons. And almost about 53,863.
836.
Yes, 836 people are still in awaiting trial. From that clip, you will see that only about 31% of conviction had been recorded in the course of the incarceration of some of these inmates. And that's not good enough. It's a persistent problem over the years that we have refused to address. Over the years, we have had circumstances where people have spent close to 15 years, 20 years awaiting trial, particularly in capital offenses. And in the past, there have been efforts by the judiciary, the chief judge of the state, to try to look into some of the matters, the files, to see if there is a way of decongesting our prisons. Quite a number of some of those inmates have been set free in the past. But the alarming number that we are seeing now calls for total overhauling of our penal and sentencing policy.
All right.
As a state.
Thank you. And Dr. Yemi Amodele.
Yes, sir.
What does the law say about situations where persons are kept in custody without trial?
Well, to be sincere, the Constitution is very clear as to keeping person in prison or correctional center without trial. It amounts to infringement of their fundamental rights. If you look at it critically, somebody is arrested, probably investigated. At the end of the day, there's one frivolous charge called, they call it holding charge. And they also call one under the ACGL and ACJA that they call it remand proceedings. Those proceedings, with due respect, is a technical way of infringing innocent persons' rights and thereby keeping them in prison. Then you see, aside from that, with due respect to the office of the Attorney Generals of the states and that of the Federation, it is the sole duty and responsibility of the AG's office to issue advice where necessary and to take up proceedings, criminal proceedings, where demand calls for it. But it seems the mentioned offices have not been doing what is expected of it per se. Because if you look at it, if you go to some criminal courts, particularly within this part of the country, you discover that some cases that are even slated for trial is so adjournment. Our witness is in national assignment, our witness father sick, our witness is doing birthday party, then cases are adjourned, criminal cases are adjourned. The spirit of the Constitution does not say criminal cases be adjourned until their kingdom comes. The Constitution says that within reasonable time. Somebody who is arrested, probably charged to court or remanded in prison custody, 1, 2, 3 months is a reasonable time within which he should have known his fate. But the reverse is the case. That is why you see the number keep on increasing in the prison. Awaiting trial keep on increasing because of this, I can say, unconstitutional procedure called remand proceedings. In fact, if you look at it, some of the remand proceedings, with due respect to the police, they are cases that can even go for lesser offenses. But because of the interior motive of the police or the law enforcement agent, they will come under remand proceedings, primarily to deprive such citizens their legitimate rights and keep them in a correctional center, which is unfair. So that area must be looked at, because the major cause of the increase in the number of the inmates in the correctional center is as a result of the lackadaisical attitude of the law enforcement agents, primarily to deny citizens of their legitimate rights and come under the guise of remand proceedings. Now, a case that's supposed to be maybe within, let's say, they call it AFRI or assault, which magistrate can easily grant bail and bail perfected, police will turn it other way around and bring a tone of capital offence with a view to remand the person and accommodate remand proceedings. Then when you come that way, the magistrate is handicapped. Though I am aware of a section of the ACGL and ACGA that calls for the magistrate to demand for the file, peruse the file, and if he sees any reasonable ground upon which such person will be remanded, but if he sees no reason for such remand order to be made, bail will be granted.
All right. Now, Ambassador Jura, we know that the law has made provision under Section 35 of the National Constitution as amended,
Yes.
also under Article 6 of the African Charter of Human and People's Rights,
Yes.
and then the protocol of ECOWAS Court to prohibiting illegal detentions. Now, can you give us some of the pre-trial rights of citizens that are being violated in Nigeria?
Okay, straight away, I think the first step is the bail, the right of the persons that have been accused of an offence to bail. And there is a lot of manipulation that goes on with the issuance of bail. And in fact, you find that there is there's this generic attitude by magistrates to deny bail to people, to persons who are coming before them, despite the fact that the Constitution presumes all accused persons innocent until they are proven guilty. The attitude of most of our judges, most of the magistrates to granting of bail is to make it onerous. They try to make it so difficult for them to even fulfill the conditions and the terms of the bail. That's the first level of the violation of the rights of persons. Then, of course, we find that some of the matters that are brought to the court, because there is no oversight supervision of many of these charges. What I mean is that a police officer who knows nothing about law prepares a charge and brings it to court without passing that charge through the office of the Attorney General or any of the legal officers who can look into those charges in view of the context of the evidence to see whether there is any prima facie case established. And that's why some of us have advocated that there should be a means by which the office of the Attorney General will either be sitting with the police in most of these police installations to ensure that some of these charges and evidences that they are gathering together are sufficient to establish a conviction. If you don't have enough evidence to establish a conviction, there's no need to take any matter to court or to charge anybody to court. So there's a need to review or maybe revisit that process of charging itself, the charging process in the police, in various police installations. Like in the US, you have a situation where the office of the DA, the district attorney, is the one that prefers the charge against an accused person, because it's regarded as an offense against the state. And most of the people who are in that department are law officers. They are people that are trained legally, that are lawyers. So they look at the evidence, they see whether the evidence will establish the conviction itself before they even go for the arrest of the person. But in Nigeria, a man is first arrested before they gather the evidence, before investigation.
Okay, now, Dr. Yemi Amodele,
yes,
let us have your thoughts on the issue of detention without trial, with particular reference to what happened to Alade and Federal Republic of Nigeria. You recall the case of Alade and Federal Republic of Nigeria, he was arrested sometime in 2003 at the former toll gate in Lagos by a policeman that was not in uniform. He was dragged forcibly by the policeman to Ketu police station, where he was kept and was detained and subsequently charged to magistrate court Yaba on a holding charge for robbery. And after that date that was taken to Yaba magistrate, he was not brought to court again until the ECOWAS court in 2012, 9 years after, gave judgment in his favor that his detention was unlawful, was illegal, was arbitrary, and violated the Article 6 and 5 and 6 of the African Charter of Human and People's Rights, and awarded him damages of 300,000 per day for the number of years he spent, which was about 2,700,000. Now, and ordered his release. Now, what, in your opinion, is the solution to incidences like that? Because we have witnessed many of such incidences in this country. What do you think is the solution?
You see, thank you. The fact remains that such incidents is a recurrent decimal in Nigeria. It has happened yesterday, it must have happened this morning, it will also happen maybe tomorrow. The major cause is that the law enforcement, particularly Nigeria police, they lack what I call knowledge of law, with due respect to them. The lackness of the knowledge of law is not in respect of arrest or detention of it, but in respect of keeping to the tenets of the law. They believe in smartness. You see, if a policeman...
What are the tenets of the law?
Yes. The tenets of the law is that the Constitution says if somebody is alleged of committing a crime, such a person whether arrested, and then you interrogate him. From the interrogation, if there is no nexus linking him with the allegation, the law says let him go. But what Nigeria police is trying to do is that once they arrest somebody, whether he is culpable or not culpable, whether there is nexus or no nexus, they will bring in a criminal tone that will bring about a capitality of such crime, to the extent that such a person will be taken to court. They will request for what they call remand proceedings. Then when they remand for the next thing is to prison, which is also infringement of such person's right. But be that as it may, you see, I say with all due respect that the lower courts, particularly the magistrate court, which is the court of first instance of such cases, there is a section of the ACJ and the ACJL that says the court of first instance can demand for that file. Peruse it, read it. If there is no nexus, if it is a frivolous charge, there is nothing wrong in at that moment striking it out. I have done similar thing in this country, several cases like that, which I raised objection, and the magistrates demanded for the file, read it, rose, and came back at the end of the day and struck it out. Police wanted to rearrest my client, and I went to the open court. I raised the issue, and the magistrate invited the police and told them that if you dare arrest those boys, I will tell you whom I am. Police went away. I've done it. So okay. I call on lawyers and all the magistrates to use what to do what the law says, and not to give a different interpretation. They should not fear anybody, because they have the power of what? Life and death.
It's all right. Barrister Dejo Lalaye,
yes.
We have witnessed in many instances in Nigeria, especially in Lagos, where police officers, in order to veer the provisions of Section 35 of the Constitution that says you cannot detain more than 48 hours, they will detain some people, then go to magistrate to get remand warrants that enable them to detain the suspects for as long as they want, some for 30 days, and then keep on renewing these things. What do you have to say about that?
I think that procedure is total aberration and it's outside the constitution of the country. Obviously, before you can, like if you report a matter in the police, I think the starting point, when somebody reports a matter in any police station, the first thing the police will ask you is, who do you suspect? Once you mention the name of your neighbor or somebody you don't like or whoever, assuming there is a theft or something like that, and you go to police station, they will ask you, who do you suspect? The moment you mention a name, police will not investigate. They will go and pick that person and put the person in their cell, first of all. And then you now have to be looking for how to pay. Not even if no investigation, they will just ask the lawyer make statement. Even if the person makes statement, I don't know anything about this matter, they will still detain him. That procedure is very wrong. Now, what ought to happen if there is a report in any station? The police are supposed to investigate. They are supposed to be to go out, find out the facts. That's what the investigation is all about. But you find that police will never move out of their station to go and investigate anything. And if they have to do that, they will still ask you for money.
Demand for money,
Now,
yes.
demand for logistics. Now, that's not even the point I want to make. The point I want to make is this, please. Just give me a minute. The point I want to make is this. Until you finish your investigation or you have a good case against an accused person or a suspicion, what you call reasonable suspicion, it is improper to arrest anybody. If you don't have that, until you have that, it is then you can go to the court to get another. But you find that the opposite is what happened in Nigeria. What they do is even the magistrate don't ask for the evidence before they issue remand orders. They don't even look at the evidence whether there is anything connecting the person with the offence that has been committed, or there is any evidence showing that there is a prima facie case before they issue remand orders. And I think that's where the infraction of the people's right comes from.
Now, who do we blame with the alarming number of awaiting trial inmates? Nigeria is among the top 10 in the whole world with the largest number of their inmates awaiting trial. Could the blame be on the doorstep of the magistrates that give strict conditions, or on the judicial? Who
everybody is complicit? The government is complicit. The office of the attorney general is complicit. The law enforcement agents, they are complicit. The magistrate is complicit. Now, in the case of the government, the criminal justice administration is manipulated most times.
How?
Now, what I mean is this. You find that most of, like I've mentioned one earlier on, the office of the attorney general is supposed to superintend the work of the police. They don't do it. That's number one. Number two, you discover that the government itself do not train the police properly on the process of administration of justice and what the right of the people is supposed to be. They only train them how to charge, how to arrest, how to detain and all that. There is no professionalism to the training of the police. That's why I say the government also is complicit. Then you also find that even the magistrates, they are not bold enough to do what they are supposed to do under the law. So